Yes, good evening to the participant of the JCJ 2022 main exam. Karibu Sana, welcome to the class. And yesterday I dealt about the three stages. Number one, examination in chief. Number two, cross-examination. Number three, re-examination. And where we dealt in a different way. But in this class that I will say that what is a false witness. Can anyone unmute and read what is given on the screen? False witness. Anyone? Unmute and read. Anyone can unmute and read what I highlighted on the screen.
A person who deliberately gives false testimony is false witness.
Yes. A person who deliberately means knowingly. Am I right? Say yes or no.
Yes, sir.
Gives false testimony. What is meant by testimony? It is nothing but say, either in the form of orally or in the form of any other. But generally witnesses will not give any document. They will only speak. Am I right? Am I right?
Yes, sir.
That's called, what they say is said to be the testimony here. False testimony is false witness. So, truthful witness. The truthful witness have been said to be the most difficult of all to cross-examine. You cannot confuse a truthful witness because he says the truth and nothing but truth. He will not say anything. If you cross-examine him in any way, he will say the same wordings and he believes and intends his evidence to be true. Definitely. A person who wants to hide, he needs the dress. That's why we say a truth doesn't need the dress. But a false, say
Yes, it needs some
dress.
That's why we sometimes also say it is a naked truth.
Yes. So he is the easiest to deal with because he does not equivocate, means he will not give any ambiguous wordings to hide the false. So he has no secret meaning and gives his answer readily and without mental serve. So that was the truthful witness. Now let us come to the hostile witness. A witness who is antagonistic to the party, calling them and being unwilling to tell the truth. And he doesn't want to reveal the truth and may have to be asked leading questions. In any form that you ask, he will not give the truth. And such a witness is...
Moreover, this hostile witness at first is a favorable witness. Later he becomes hostile. What he has said, what was expected, what is expected of him, he doesn't say. He says something which is hostile.
Yes. And most of the cases, especially in the criminal cases, the other party may threaten him. And most of the people become hostile. When they given the 161 statement, if I not be mistaken, CRPC, they will give the truth. I mean, they will give what they have seen, what they heard, what they did. And they will sign also. But when the matter comes to the examination, at the time, even examination in chief, they will become a hostile. So, and they never reveal the truth. And yesterday we have given the answer because sometimes the witness will not say anything. So such a witness is said to be a hostile witness. And yesterday that we all made that a hostile witness can also be called an antagonistic witness, an unfavorable witness, and adverse witness. So biased witness. And here a witness may be said to be biased when his relation to the cause or to the party is such that he has an incentive to exaggerate or give a false color to his statement. But he knows that he is giving the false color and he is exaggerating and he is biased towards his statement to suppress or to prevent the truth or to state what is false. Bias is that which excites a
You may
disposition.
also say that he is partial and not impartial.
In the both
He
the
is
way
very
that he will
partial.
make it out, but he will not give the exact truth. He will try to discolor it, and sometimes he will not give the full truth. Only he can make it a half truth, and because he makes the color of the falseness to the truth, and he will not reveal it. That's why we can say biased witness. Report matters as they are wished for rather than as they are. Actually, what he is going to say, he will not say, but he color it and he present it. And such witness is called biased witness. Now let us go to the expert witness. There are two types. They are divided into two classes. Number one, professional. Number two, non-professional. A farmer called to testify as to the proper method of curing may be fairly considered as a type of the non-professional class, and he will not, of course, non-professional means he is not a professional person. Where a physician is a professional and hence testify to the mental condition of the body may be taken as a professional class. Even a fingerprint
But,
expert,
in a certain subject, expert in a
handwriting
certain subject.
experts, these are all the experts, they are professionals. Even to testify
Specialists.
whether signature is genuine or not, and an expert will give the answer for that one. So those are said to be the expert witnesses, and the non-professionals are said to be they are also the witnesses, but they are come under the non-professional class. Then we will see the court witness. What is meant by court witness? In civil and criminal cases, the judge has the power to summon witnesses as court witnesses and examine them. They can be cross-examined by both the parties as provided in the section 165 of Evidence Act. Such cross-examination is not restricted to the points on which he has been examined by the court. Now the question comes over there. Generally, the witnesses are introduced by the parties, those who are calling to give their testimony. Then what is the court witness? At that instant, a judge has the power to summon the witnesses. Some other witnesses, a judge will summon him, and such witnesses are called the court witness. Not the parties will produce them. Am I right?
Yes.
So section 165 clearly makes such witnesses may be cross-examined, is not restricted to the points on which he has been examined by the court. And both the parties can examine and chief examine and cross-examine and re-examine also, provided if there is such a material, they want to get it from the witness. So re-examination of witnesses, we already dealt it. When something has come out or the cross-examination being closed, the duty or re-examination develops upon the counsel on the other side. If usually undertaken by the leader, even although the examination in chief had been conducted by the junior probably, because it is supposed to require the skill and caution which only experience can teach at the time, after the cross-examination, the senior may make the re-examination. Of course, for the re-examination again, he needs the permission of the court. Or a new thing he wants to show it, at the time the re-examination can be done. Am I right?
Yes, sir.
Okay, now let us see we'll come to the conclusion of these three stages. Examination of the witness is very important for any case, whether it belongs to a civil or criminal nature. And both the procedural law explains the examination of witnesses. Section 135 to Section 166 of the Indian Evidence Act and explains the examination of the witnesses, in which act cover all the things from 135 to 166, like who can first examine the witnesses during the examination of the witnesses, and what are the relevant facts that are accepted during the examination of the witnesses, and what are the question asked by an advocate during the cross-examination of the witnesses and what questions are not asked during the cross-examination, and also tells the power of judge during the examination of witnesses, and that at last give the provision related to the power of the jury. Of course, no jury system is no more there, and access to ask the question during the examination of the witnesses. Effective cross-examination can make the difference between the winning and losing the trial. So, cross-examination is a very chief, so that it can determine whether winning the or losing the trial. Although the cross-examination can be the part of the trial, that is the most fun for the experienced trial lawyers. Preparing good cross-examination takes a lot of thought and hard work. So, your all power would be shown in the cross-examination. Am I right?
Yes.
So now let us go to the leading questions. So section 141 to section 143 of the chapter 10, part 3rd of the Indian Evidence Act 1872 deals with the leading questions. Section 142 and section 143 provide a circumstances under which the leading question may be asked or may not be asked. Leading questions have been defined under section 141 of the Indian Evidence Act 1872. Can anyone read the meaning? Unmute and read loudly.
The expression leading questions literally means a question which itself suggests answer. As expected by the person asked the same, any questions which leads to answer, or a question which is pregnant with the answer.
The question already having the answer in it in disguised form. That's why they say the question which is a pregnant with the answer means already it is there in the womb. So definition is 141 of the Indian Evidence Act defines a leading question as any question suggesting the answer which the person putting it wishes or expect to receive is called a leading question. So Bentham said, defines the leading question as a question is a leading one when it indicates to the witness the real or supposed fact which the examiner expects and desired to have confirmed by the answer. Like an example which is given over here is, yes, except the host, participant should read. I said participants, and which I highlighted here.
Is your name so and so?
For instance, you can say, whether you are a Professor Mohammed Saheb Hussain, answer is yes or no. Generally, it is he will give the right question only. So you say, is your name so and so? Means so and so name is there, and he says yes. Do you reside in such and such a place? And he will say that, do you reside in the so and so area? Answer is yes.
Yes.
And
So for all these leading questions, only yes or no type.
Yes, yes or no type is there. Generally, yes or no type is there. So, are you in a service of such and such a person? Whether you are working under so and so place, under so and so office as a junior, and have you not lived with him for so many years? So, it is pregnant with the answer in it. Did you see him enter X office and take a file? Answer is either yes or no. And that way, they can give it such questions not supposed to be asked either in the chief examination or cross-examination.
This is only in cross-examination.
Mostly, these should be come in the cross-examination only. So it is clear that under this form, every sort of information may be conveyed to the witness in a disguised form. It may be used to prepare him to give the desired answer to the question about to be put to him. A person who puts such a question wants to desire that he would like to give such an answer. And the examiner, while pretends ignorance and is asking for the information, is reality giving instead of receiving it. So actually he is supplying the answer to him. When such a thing would be there, the party counsel will say, objection. Of course, depending upon the court, I say, Mr. and Judge or whatever that addressing that you can make it out. And the judge will make it. If it is a leading question, he say, objection sustained. Suppose if it is not a leading question and he wants to draw some other information, then he say, objection overruled. Who says?
Judge says.
The judge or magistrate, the presiding officer of the competent court will say. So Taylor is one of the author. A leading question, I quote, a leading question, in other words, is one which suggests to the witness the answer desired or which embodying a material fact admits of a conclusive answer by simple negative or affirmative. As Kolikonda Sharad Babu has made it very much clear, answer should be either yes or no. Negative means no. Affirmative means
Yes.
yes. So I unquote. So that is the Taylor has given such a definition. It is a question framed in such a manner that it throws a hint as to or suggests directly or indirectly the answer which the examiner desires to elicit or extract from the witness. E.g. What is meant by E.g.?
Exempli gratia.
Exempli gratia, E-X-E-M-P-L-I, exempli, space gratia, G-R-A-T-I-A. It is the abbreviation for the Latin terminology E.g. E full stop, G full stop, comma, continuation. That is the way of writing. When a witness called to testify to an alleged assault on A by B is asked, did you see B take a stick and strike A? The question is, did you see B take a stick and strike A? That is, or did you not hear him say this? The answer is either affirmative or negative. You should have to make it out. Of course, here I would like to say, did you see B take a stick and strike A? Because when you stick, we generally will say cane A. Can you say strike A, cane A, which is appropriate?
Cane,
Or
not
it is a stick, hence he wants to strike.
You
If it's a
can
cane,
use-
he can want to cane it.
you can use
Either
strike
it is a stick or a cane, doesn't matter. The act is called caning.
No, striking
Even
is
if
different.
you use
Striking
strike,
is different.
no
Caning is
problem with
different.
it.
Okay, here you want to say the teacher will caning it?
Yeah, the teacher doesn't strike a student. The teacher canes the student.
Okay.
Striking is attacking something which a metal.
But here the strike, they say what? The use the stick, they say.
It's caning.
So anyway, that because English is
Anyway,
not that much,
Yeah.
that much
Yeah.
grammar would be followed over there, but idea is more important factor there.
Yes.
But anyway, it doesn't matter. But a right way also you should have to use it. Because you cannot say with the hand he kicked him. One cannot kick it with the hand.
Only with the legs he can
The
kick.
appropriate word, as far as possible, should be used.
Yeah.
When
With
it
the
gives
hand, he can
clear
punch.
meaning, we need not bother about the word.
With the hand, he can punch.
Okay. Yes. When a leading question must not be asked, that is who says 142 of the Indian Evidence Act, leading question may not be asked. What is defined in the leading question? 141. What should not be asked in 142? That is the examination. Yes, he said, the leading question may not be asked in examination in chief or in a re-examination except with the permission of the court. Whatever the cross-examination, whatever the cross-examination.
Cross-examination, again, the re-examination opportunity will be given provided the advocate asks.
Yes. But here he said 142, A leading question may not be asked in the examination in chief or in a re-examination except with the permission of the court. But a leading question not supposed to be asked in cross-examination also. But most of the people will ask the leading question in the cross-examination, but the counsel make an objection, and for that a judge may decide it. Am I right?
Yes.
So section 142 runs as follows. Leading question must not, if objected by the adverse party, see, if objected to by the adverse party, be asked in an examination in chief or in re-examination except with the permission of the court. The court shall permit questions as to matter which are introductory or undisputed, which have, in its opinion, been already sufficiently proved. So when leading question may be asked, then the grounds. A leading question may be asked in the following cases. According to section 143 of the Indian Evidence Act, a leading question may be asked in cross-examination.
Yes.
Of course, if it is objected, the discretion by the judge either sustained or overruled.
Overruled.
Under section 142, in examination in chief, leading question can only be asked with the permission of the court in certain matters. Number third, when the witnesses have defective memory, it may be agitated by a few leading questions.
Leading questions.
If you such a thing, okay, it may be allowed, but with the permission of the court again. Fourth, when the object of the leading question is to contradict another witness as to the expression used by him, but which denies having asked, the witness may be asked a leading question. So, another witness is giving a contradictory statement to the statement at the time, they will ask the leading questions. So, objection to the leading questions. Objection to the leading question is not that they are illegal. No, they are not illegal, but that it is pregnant with the answer. But only that they are unfair, because they are trying to give the reply in the question itself, helping the witness to catch that what actually he wants to get it from him, means witness. The rule excluding leading question is intent to prevent the unfairness in the conduct of the inquiry. The Act gives absolute discretion to the court to allow or disallow leading question. So in one of the case law, in Varki Joseph versus State of Kerala, the Supreme Court held that the prosecutor ought not to be allowed to frame the question in such a manner which the witness may answer in yes or no, as to enable him to elicit such answers which he expects or desires. It also held that allowing such leading questions would offend the right of the accused to a fair trial enshrined in the Article 21 of the Constitution of India. So, it is unfair. Even a constitutional provision can also be tapped, because it is not a fair trial, which is clearly mentioned in the Article 21 of the Constitution of India. Participants, what is Article
Yes, yes.
21 of the Constitution of India? Participants, I said, not host.
Right to life, sir.
Pardon?
Personal liberty.
Repeat.
Right to life and liberty.
Life and personal liberty.
Yeah, that is, I would like to get from the participant side.
No person shall be deprived of his life or personal liberty except according to the procedure of the law.
Yeah. That is, means due process should be followed.
Yes.
Am I right?
Yes.
And this due process, from which country it is taken? Sir,
British.
we already passed the screening test, sir. Why you are asking the multiple choice question? I did not give
The
the option here.
Constitution of USA.
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 But in the USA, they don't say due process of law. They do use another terminology. Can anyone?
Procedure established by law.
Say again.
Procedure
Procedure
established by law.
Yeah.
So what is the difference between these two?
I
So what is the
appreciate.
difference between these two?
No, only terminology is different.
There is a difference.
Only
USA,
terminology
they
is
say
different.
freeway. In USA, they say freeway, and in UK and India, we say highway.
See, for instance, you take private international law. It is generally the UK terminology, and all Asians will say private international law. But in other places, especially in the States, they don't say private international law. What do they say? What do they say? Conflict of laws.
Personal international law.
Conflict of laws, they say. Okay, now let us come to the point here. Section 143, when they may be asked, leading questions may be asked in cross-examination. Yes, a leading question can be put in the examination in chief or re-examination with the permission of the court. The court shall permit leading questions to be asked in the examination in chief or re-examination in respect of the matters which are of introductory or undisputed nature, or which matters in the opinion of the court have already been sufficiently proved. It can be asked where it is not objected by the adverse party. A leading question may also be put to when the adverse party objects to it, but the court overrules the objection if it is in the opinion of the court that question pertains to the matter which are introductory or undisputed or which have been sufficiently proved. Even myself also, I did not read it that much thoroughly. I was in the impression a leading question cannot be asked in the chief examination chief and re-examination. But now I found they cannot be asked in the, they cannot be asked, but they can be asked only with the permission of the court. But when they come to the matter of the cross-examination, yes, they do put it. It is only the parties, counsel make the objection. Subject to the correction. Any correction? Kolikonda? Sharad Babu?
No, sir. Only if the opposite advocate objects only, then the judge will decide whether that leading question may be asked or not.
Okay, let us see then. Yeah. In Barindra versus Roar, it was held that the court has to determine and not the counsel. See, here they say the court has to determine and not the counsel whether a leading question should be permitted, and the responsibility for the permission rests with the court. So the court is the final authority. Is it clear?
Yes.
sir.
It is stated in the
advocate has the right to object, but the court will decide whether it is sustained or
overruled. So the final say is the court. It is decided in the Barindra versus R. What is R stands for? Participants. What is R stands for? Participants.
Regina.
Who said? It may be
Venuna.
Rex.
Rex
It may
or
be
anything.
Republic.
No. R is, I think you have described in the last class sometime back.
But when you say R versus Abdullah, there Regina, that is the Empress, Queen Empress versus Abdullah. In the dying declaration. Yes, we also asked what is the Privy Council, a Andhra case law in the dying declaration? Somebody gave the answer already. Of course, I am going to deal, if the time permits, the dying declaration. Both the things I will deal there. So here what they said is, this section always permits the leading questions being put in the cross-examination. The reason is that the object of cross-examination is to test the veracity and credibility of the witnesses, to express any inaccuracy that exists in the testimony of the witnesses. It is so because the party which calls the witness always tells him the facts in advance. Definitely. And he may train also the witness. Whenever you ask the question, you repeat the same wordings No change of wordings, which the witness is likely to use in the court. As a result, the witness would remain hostile to the cause of the adverse party cross-examining him, and he will be biased in favor of the party calling him. Sometimes the witnesses will be tampered. That is the reason the bail will not be issued. Am I right?
Mm.
Yes, yes.
If the bail will be issued, definitely will tamper the witnesses. Because the nature of the offense is in a such a nature. At the time, the bail will not be issued to him. Otherwise, he will say, if you come to the court and give the statement or witness, I will see your end, he will say. Because he already committed the murder. Or either he commit one murder or two murder, doesn't make any difference to him. Am I right?
Yeah.
So section 146 questions lawful cross-examination. When a witness is cross-examined, he may, in addition to the questions herein before referred to be asked, any question which he may ask it in the cross-examination. Like number one, to test his veracity. Why he wants to make it out? He wants to see the accuracy.
Veracity
Authenticity.
means truthfulness.
And the truthfulness and accuracy and veracity to discover who he is and what is his position in life. This also counts. And that's the reason character also an important factor in the witnesses. Of course,
Yeah.
video has separate section to question the character of the witness. So third, to shake his credit by injuring his character. Although the answer to such questions might tend to directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to a penalty of the forfeiture. Even sometimes, no, witnesses will be prosecuted when they give the false statements. So, provided that in the prosecution for the rape or attempt to commit a rape, it shall not be permissible to put the question in a cross-examination of the prosecutress as to her general immoral character. Of course, these are the cases will be done in the camera. Am I right?
Yes, sir.
In camera proceedings.
In camera proceedings.
Yes, that's called camera proceedings. So this is about it. So now the still time is there for the first session. It is 8:54 now time is, and I don't know because I started a bit late. That's why we can meet the 8:54. And the next point which I want to deal is the dying declaration. So Kolikanda, are you ready with the second session?
Yes, sir.
I will try to deal with it as for.
Yes, after the 5 minutes break, later that we'll make it out. And let us see, make an attempt. If they are present over there, we can continue it. But if you make a continuity, then definitely they will be present. Participants, what
Can
about
you
your view?
please share the
Yes, present.
Okay. No, present. Do you present in the second session also?
Yes.
Okay, till the first session ends over there, let me continue it. Dying declaration. See, when a dying declaration is asked in the short notes, how much you have to write? The same question asked in the long question, then how much you have to write? So your answer should be according to the. Your answer should be according to the
Question.
marks given over there in the question.
Mm.
So if it is a short question, giving definition and giving one or two
One or two enough.
case
Section
clause, that's
and one or two examples enough. But it's a long question. You have to give the ingredients also. Dying declaration ingredients, and for each ingredient you can suppose it. It is acceptable, not acceptable. Both the way you can make it out. So dying declaration is a statement by a person as to the cause of his death, as to any of the circumstances of the transaction which resulted in his death and becomes irrelevant under section. Now you tell me, how do you read it? I want to test your knowledge. Section
32 class 2, sir.
32 clause 2. 32 clause 1.
32 clause 1,
Clause 1,
not
1.
subsection 1. Now you tell me the distinction between a subsection 1 and clause 1.
No, I'll tell you. 32 clause 1 is a plus, and if you have after one, you have one another clause, then you call subclause.
See, here I made the distinction, we can say. For instance, if you take 53, capital A, instruction of reference to transportation, immediately there is one is written. At that instance, we should read section 53, capital A, subsection 1. And immediately 2 is written. But when you come to the matter of the Indian Evidence Act, Bare Act, I will show you now the Indian Evidence Act, Bare Act. There, it may be a different style it will given. That's why Indian Evidence Act, yes. And here, if you happen to see the section Control F 32, you make it directly, you can go to. See, 32, when you go to the section 32, I will show you the way it is written. Yes. See, 32 it is written over there, but it is a subheading for the section is there. Cases in which the statement of relevant fact by a person who is dead or cannot be found, etc. is relevant. And later on some explanation is given, and in the following cases, colon and dash, and one is written over there. If you closely watch one, the one is in italics. Am I right?
Mhm.
Yeah.
If you closely watch one, the one is in italics. It gives a sense it is not subsection 1, it is the clause 1. So section 32 clause 1, when it relates to the cause of death, when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in case in which the cause of that person's death comes into the question. So section 32 clause 1 says about the dying declaration of the Indian Evidence Act. And again say the section 2, class 2, class 3, class 4, class 5, and class 6, class 7, class 8 total are there. So we will read as a class 8. The good indication is after the section, only the section heading is given, directly the one is given over there at the time we can say subsection. But the explanation is given, then we can given the colon dash and dash or some other thing, and they are given 1, 2, 3 Arabic numerals. At that instance, we can say it's a class 1. So that is
Sir,
the
I have a
distinction which I want to make it out. Yes, any question?
Yeah. Now, what is the difference between a dying declaration
Say
made
loudly.
in
I could
England?
not hear properly. You speak a bit nearer to that one so that I could
Okay.
hear.
Now, okay. Now, what is the difference between a dying declaration made in England and a dying declaration made in India?
Even I did not know unless until you go through that dying declaration of England, dying declaration of India, what the distinction would be there. Then only I can able to give the answer for that one.
Okay, I'll tell
And
you
if
that.
you contribute anything, you can contribute.
Yes, I'll tell you. In England, dying declaration will be admissible only if he
Close
knew.
to the smartphone or laptop.
Okay, dying declaration will be admissible only if he knew that he is going to die. That is in England, but in India, it is not that case. In India, unlike in India, a dying declaration can be made at a time when the victim believes that he will be dying because of the injury, or if he is believed that he will not survive.
Suppose if he survived.
Yeah,
Even if
Suppose
he
he
survives,
survived.
even if he survive also,
even if he survives also,
Even
it
if
is
also-
valid, sir.
even if
will
survive,
be-
it is valid.
Okay.
It may be used as a corroboration.
Is it any section clearly says in the Evidence Act?
Yes, yes. Something says I have also. remember
Okay, let
that-
us see, because we are only on the bank. We are still not going to the full depth of the water because I am short questions I am dealing it.
Yes. No,
So
this
when I go in the depth of the water, I will give the explanation when it can be valid, when it cannot be valid.
Yes.
Suppose if it is not died, at the time, what is the result? What is the phenomena? What it is the action? We will see it.
Okay.
So here, the question is where we have gone. This we have gone to some other thing. Dying declaration, yeah. So now we get made it very much clear. Section 32, Class 1 of the Indian Evidence Act, in case which the cause of his death, person's death, comes into the question. It is true that dying declaration is not a disposition in a court, and it is neither made on the oath nor in the presence of the accused, but dying declaration is admitted in the evidence by way of an exception to the general rule against admissibility of the hearsay evidence on the principle of necessity that is made in the Tapinder Singh versus State of Punjab 1972, second volume Supreme Court cases 113 page and 119 also is the citation there. So it will be taken only by the yes police officer,
Only by the magistrate.
Magistrate.
only the magistrate. And which type of magistrate? First class magistrate or any magistrate?
Any
Competent
magistrate.
Any magistrate will do.
As for my knowledge goes also, there is no specific thing that a first class magistrate only could have take the dying declaration.
Sir, I have a doubt. For example, within the time the magistrate comes, the victim is going to die.
Sir,
Can the
dying
doctor?
declaration can be recorded by anybody, sir.
Yes. Can
Yeah,
be
we'll let
recorded.
us see. Suppose if it is recorded by anybody till he reaches over there, whether such an evidence, whether it is deemed to be a dying declaration. Even FIR can be as a dying declaration.
Yeah, even a dying declaration can also be a will.
Okay.
But that applies only to a soldier when he's dying in the war.
Yeah.
Anyone, not for anyone.
Yeah. That is
If
there. That
I'm a
is there.
soldier, and my other colleague, he is also a soldier, and if he's going to die, and if he says that all my property belongs to XYZ, and if I give that statement,
Okay.
that is valid. That is valid.
Okay. Right. So let us see the dying declaration is the last statement made by a person at a stage when he is in serious apprehension of his death. Apprehension means fear of death.
Fear of death.
And expects no chances of his survival.
Yes.
At such time, it is expected that a person will speak the truth and only the truth. Even the person who has taken the full drink, he may also give the truth.
It's on the lips of the dying person.
Yeah, am I right?
पीने के बाद ही सब कुछ सच बोल देता.
Where such a thing would be there, why in the court they will not allow them to take the drink so that he could give the truth?
He'll go extra mile of telling the truth.
Okay. But it is not the proper way to serve the alcoholic drink in the court. Okay, normally in such situation, courts attach intrinsic value of the truthfulness. See, extrinsic and intrinsic, both are there. Truthfulness to such a statement. Once such a statement has been made voluntarily, it is reliable and is not an attempt by a deceased to carve the truth or falsely implicate a person, then courts can safely rely on such a dying declaration and it can form the basis of conviction. Even sometimes, no, that fellow will die. Even dying also at the time, he will say that you will be punished and he will give the false statement. At that time, what will happen? The court will see whether what he said the truth or
The
not.
declarant should be in fit condition, sir.
Yeah, because for the revenge he wants to make it out. If it is proved that the revenge would be there between them, and hence he uttered the word, "My death cause is so and so person." Even that person is not over there, because he believes that he made such an attempt to him, because the killing persons he doesn't know. So more so, where version given by the deceased as a dying declaration is supported and corroborated. See, this is the wording are there. It is supported and corroborated by other prosecution evidence, there is no reason for courts to doubt truthfulness. Of course, truth is truth. That's why we'll say naked truth. A naked truth doesn't need any corroboration, nor is there prosecuting evidence also of such a dying declaration. So it is made in the Sudhakar versus State of MP 2012 case law that is made it clear that a truthfulness doesn't need any corroborative evidence or the prosecuting evidence also. So a deathbed or dying declarations are constantly admitted in the evidence. So Gausia, do you want to speak anything? Because I could see that you're speaking. The notification
No,
has
sir.
come to me. Do you want to speak
No, sir.
anything?
Sir, dying
No, sir.
declaration should be recorded immediately, sir. There should be no time gap.
Which one recorded immediately? Yes. Yeah, when the dying declaration is concerned.
Sir, there is one case, sir, Chilikaluripeta bus burning case.
Okay.
We can clearly understand, sir.
Okay. Yeah, please,
There is
if you have the case law, you please send to us or keep in the group so that everybody could know it and we can discuss also.
Okay, sir. Okay.
Right, that is a quite good idea. Because the learning process, I tell you, you can search something, I cannot search. When I can search something, you cannot search. So, if all searching would be there, new ideas will be generated. So,
Okay,
here that what I want to see, till it comes now, I will continue it, but the time is up, I believe. Because now the 9:10 is going to be happen, and our second session also be there today, but only the two members will deal. Shall I stop now? Then I will give the 5 minutes gap, then I will start again.
No. One question.
Yeah, please.
Let's presume you have two dying declarations.
Yeah.
So which one will be authenticated? Which one will you take?
Yeah.
Is
Corroborative
second-
evidence and prosecutor's evidence to know that which one is the truth one.
Hmm?
Subsequently recorded statement will be considered, I think.
No.
When the two wills are there, which will be predominant?
The first dying
Then
declaration. No.
corroboration.
No, 1 minute. In case there are two dying declarations,
Okay.
the first dying declaration will have to be considered more reliable and trustworthy as against the second one.
Okay.
This was said
Then
recently.
in the case of will,
One minute.
the last will is considered valid.
Yeah.
This was recently held. This was
Okay.
recently held by
Please, give that any case law is there, please give the
Yes,
site
yes,
the
yes.
case law and you post it
Yes,
in the group so that we
sir,
can know
1
it.
minute. You're not making me speak only.
Okay.
This was recently a week back held by the Supreme Court in Malkan Singh versus State of Haryana.
Okay.
This was 1 week back. This case law has come out.
Please post it.
Yeah.
So
Definitely.
that means dying declaration, the first one will be more priority than the second one. But when it comes to the matter of the will, second will is more priority than the first will.
Yeah.
With
That is
this,
different.
I would like to close my today's session. I will give the 5 minutes gap, then we'll start the second session later.
Okay, sir.
Thank
Same
you very
link, same
much.
link.
Bye. Goodbye. Jai Hind.
Jai Hind, sir.
When I say
Same
Jai Hind and
here.
I leave the meeting, I should have to say end the meeting for all. Yes. End.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे विचारित सुनि तव उदार वाणी